onim se chama ntwibu si akochema Wontumi said the nyoma si kweka kono ene wohwe yewra miracle aboagye de enso ebeka ho ne ade na chema Wontumi hwe be wanhwa na ne service to the nation no wanhwa ebetumi abaso ebusua hwan ena 80s ankomo we endie nti ena mpenifo ye kire se wanhwa na chairman ntwibu si akọ 15 to 25 years eba years atekodae no wanhwa na sa conversation ne besan so abaso bi ebusua is this going to be a good news and answer sign ena Ghana ye pese ye man ye and also man no ye pese ye de no kre ena teno man ni
ai utasante mampo no maame ye o man condition ai na munye miracle aboaje kire no kino ko gina ho no o ka sa ya mo che ne ko na Reverend Charles Owusu asem am so okay media tum koto dwemu misime wukura I would declare with that advice
osiden
was it koma wo ni pa koma wo koma no se wo nkodi adwemu sa
obekoma wana kwame ya nukreto do
koma wo
nukreto do
I say oko police station wa was it the tables hotel I friend and lawyer na the lawyer say oh no ni NPP ni ne kasa no ka chen say wo ye ya ade a wo fa hu nhim the tables hotel but the lawyer is fantastic.
We are brilliant.
Brilliant.
Oh, smart.
What did you put one of us on the young NPP ni
and then kasa
Ochia wadan.
Shaka no ku
Ani okinki.
But ani okinki. Idi anu no me hwese ye kire no no and then me hwe crowd e be ko ho. Free KOKA now. I say about social media free.
Ah, okay.
Free one KOKA.
KOKA now. What do you mean? Hame. You about me am wa ba mu no. Enfie nwotwe KOKA ya ma hu.
Mantine mantine didi yo.
Ya kwa tiri da.
Chise.
Oh, for something run da. Ensu ato eja ye mamponi ba.
Afa na wo be ha wani sai. Hey, a presence my dear and then Kurikurum.
Debbie. Nana. Kwadana ya mama auto. What do you when I cheer my baby amam? A cheer the
baby.
Nana, would be a pipe. If you go, Anyama. Coco, but the way is so Coco, Enke ebeyima wa mu wa pama wa mu ye uden KOKA wa mu ba bie mu yo in politics panini ka sam kire me eni theories kura bibisa bi say adana se mo politicians mo ba ben ma obi obeyi deda ma mo mu ye bonu ni e chi no mo ma ne he What's that, Kwame? And some they say, Pamian. Wow, a great anoa. Yana, I we are bonomia, the Adena, a year quine. Was once a be white crashing hard rocks, no near the idea, the bee boo, and near the ring in a was okay. Oh, see a chance, see a level quanus near the good to me now. I'm saying, I was it. On said, Sadia, the discipline that's near the co. I was saying, yes, sir. Sir, be a quine of broom. Was I cast one to us in your or miss a quine? No, when I see us, I see one my own woman you did it. Any idea? One Casano, why you did this? It's all the to baby. But you are for trouble amount. And no, you one. And was up or a penny pound or circle say, wouldn't my boy be a friend I gave you? Not so mean my issue. No, say I just already, and I'm so what then soon. Now, yeah, was one and now soon any sa yes, or yes, I'm not particles, no. Echo from no in your quiet day, asa. Was it in my friends, and I'm sitting a friend I gave you. was okay.
Ojini nsuani.
Ojini nsuani. Wasi aboy. Sani na ndu ase ankonse nsuo.
Ozise muti.
Ade nsuo fa no.
Wo pese wo se nsuo na le na ndu ase. Wasi nipa ni bi wo wa ye ne wo mo ya amanyokuo no wo mo ya agirigiri nsu. Se nsuo ne wi kwa ase kakra bi obese. Scandal bi aba ye be bata wo. Enam se a wo se entina ema nipa bi onti wo se se wo di amanyokuo no mu a di mu yie. Eye nsam nyina na ye ka. Eye nsam nyina asem bi wo kora ese wo hena no asem bi wo so a ese chiame ano.
Nukre.
Na ye fa democrat ani ko enti KOKA wo se free KOKA now. Free KOKA now. Free KOKA now.
Obako.
Why?
Kwame.
Abusua chema Wontumi ena Kwame Nkrumah Tikese apel lawyers ama mu kirem. Wontumi lawyer lawyer atachia. Ne addresses a watro agese mu no de nyoma bi ahihye mu a kire se omo pese omo suspend asem no judgment na court no pese ode ba no animu nsensem bi a o highlight. Na abusua me pese yebekọ ne akwakotim se ebegina anase enyina no nokure bi ewom.
Nana ye wa chama Wontumi asem a omu die no. Manu butusumu na so.
Oji wa no siye.
Ejima no siye. Se nyame anfa fie ne koba se. Ekobona. Emra ne se wa nam kura no. 15 years. List. One just judge no. Entimi mountain. Emra chechere.
Wontumi from
Daddy
Gina 50 wa eno cry di sawum.
Aha ne di sawum kopim bia aduonum
15 to 25 years.
Yes.
The list is 15.
Yes. Defaulting by false pretense.
The one who judge bia.
Yeah, that no background ni iraku. Ba mostly no ya na judgment no oba no watchro dada. Afei judge no ashe date for judgment and now was shared the accused and the prosecution say woman file woman addresses yanto akwa nkoso anso yetia lawyer for chama Wontumi say oh okay mayi me wafiri mu niam bi wo a na enye fair throughout the trial no and na yeru attach ya beso mu obeso mu no. He prayed to the court to say, "Oh, mama, the break akra now one fan file address afe na waba." And was the deadline on or before 13th of this month. And one was file address in the aba address in the ba ko mu pa ni say he is asking the court to stay the judgment. Na ehon na me person no di nkomo efa as a lawyer e dia na woni ye beche by way of education and thoughts.
It is within the rights of counsel attached to pray the court to suspend or hold the delivery of judgment, but the thing is, he must adduce cogent evidence. So, idea the occasion is so fundamental that it can affect the delivery of justice. That will also be contained in the address. Okay, you must give the court an indication of why he thinks, sir, the court should stay judgment. Because you can't pray the court on nothing. And an empty sack cannot stand straight.
Baba, court libium an empty what?
An empty sack cannot stand straight.
Okay, just a what are we in entimi nyina brane entimi nyina ho. Just a baby wo.
You must build your case and convince the court says staying judgment will be in the interest of justice. You must build the case. One can say the Supreme Court will rule in your favor. But at the end, Emma will say, court and staying in the judgment, and then say, there must be something, there must be a premise, and it must be so fundamental in your view that you think it can affect the delivery of justice. I mean,
Mami Musa question be wa be a conversation is he seeking on behalf of his client to arrest the judgment?
That's the arrest of the judgment.
Me bo baby a yedro ye wo any precedence in law say baby a yedro ya judgment is set to be delivered. Now obi akose meye na Minerals Act na de bi wo mu a ese na we na chese is it amounts to say ye open case bi mu ana.
No. Yes, amounted to the matter where a court is sitting on even this asking for some matter. It's a precedent in that matter.
Okay.
Whether or not a person who files for the renunciation of citizenship and files to contest an election before a certificate of renunciation is issued is otherwise qualified to contest the election without the certificate of renunciation. What does the constitutional provision actually mean? So that was an interpretation. The High Court in second or so had to stay the judgment. I mean, had to stay proceedings for the matter to be escalated to the Supreme Court for determination. So it happens as a precedent. Even in this case, even in this particular case, Wontumi case, and the appeal na Kaniano or a lawyer. Now, and the appeal did not raise this matter. So again, it will immediately bring into your mind the case of Nimaka, not Nimaka, Panda MP no design. Indam. Not lawyer the Indam case in Panda no Tamale. Sa lawyer no on the almost a court room judgment no will appeal against the judgment. But Mindam ebi file no buy ebekire Gary Nimako. Gary Nimako said appeal. This matter is not a matter of appeal. It's a matter of judicial review. Because court no need to me to sit on the matter in the first place. So we abandon the appeal and go to the Supreme Court. Of course, Supreme Court no. The court agreed with him. So again, in the Wontumi case, and the appeal did not see anything wrong with the Minerals and Mining Act under which way Wontumi and EOCO and his company were charged. But attached here is seeing something. But it's not the seeing, it's the conviction that what he is saying is actually tangential to the delivery of justice. I'm making myself clear.
Yeah, clear.
Because courts be every day, every day we interpret the Constitution to guide our activities. Courts has interpretative powers of the Constitution. But where in the implementation of the Constitution, they interpret the Constitution. But where there is an issue of interpretation, then that issue is within the exclusive jurisdiction of the Supreme Court.
Hey, counsel. So, lawyer for the defense, Wakanidiano, is the court bound by it say, Wontumi and Koswala and for judgment in the come 20th of this month, name Jisabia or train for the constitutional interpretation as the defense counsel.
This one is a statutory interpretation. It's a statutory interpretation. It's not a constitutional or say statute no, or minor and minor act no. There's a problem of interpretation on that. Okay? And then I mean, can say every court interprets the statute. Okay? But where there is an issue of what it means, you can escalate it to the Supreme Court.
So, in case of this, why not we bet me a stop court and say, don't deliver judgment. Arrest judgment. Wait until the Supreme Court no the other tree any moon you be can ho asem awie.
It's a prayer. A prayer.
En koto sere na wo sere.
Yeah, quite sorry. God can decide to answer our prayers or not answer. You can, it's not bound.
Says court no pa obegiatum opa onyintum.
That's all.
It just when I walk and onye na dwene se bia he's seeking say ye open case na niam bi wo a e bia okeka na won addresses ni mu no ye deal with it.
Oh, court no provide me. And if you think that my understanding of the law is wrong, that my judgment does not prevent you from seeking release at the Court of Appeal or the Supreme Court. Court number 2 because
council the prayer no what the idea be 13.3 or say alternatively, should this honorable court decline the request for constitutional reference to hold that the Republic has failed to prove beyond reasonable doubt the essential ingredients of the offences charged against accused person 1 and the accused 3 in counts 1, 3 in counts 1, 3 and 4. Bueno, na opeso kire se se court no anye saa e bi aniema bi wo wa anko yi a there will be travesty of justice ana.
No. So even that prayer, the second prayer, no, defeats the first prayer.
Oh, sir. What do you say, Mukakre?
Because you see, second prayer, no, say offense, via it say we are inquiring via war the ingredients. So, what the abe at the cracker. You can call it and cracker.
Okay, 101.
Okay, Wontumi. And I would be why Antuma Yambuno. So every offense has ingredients. So you must establish those in the ingredients beyond reasonable doubt. You must establish that the accused person has committed that offense. And why you say the accused person has committed that offense is that the ingredients of the offense are A, B, C. And the accused person has done them. And you show by evidence, say, why, yes, I did. And show, even in cross-examination, I did the occurrence. You will show that. Once the man tried by the ingredients, then you have not established the offense. So if you are praying alternative, the prosecution has not been able to establish the guilt beyond reasonable doubt, because once the man establishes the ingredients, then that prayer is an appealable prayer. It's not interpretation.
Oh, it's an appealable prayer.
Mm-hmm.
Oh, now wait, you're fun.